In the 1960s, the United States had become involved actively in destroying prejudice and racism in the South. However, others were actively disagreeing with their forward action.
The case of Edwards versus South Carolina is a good example of the First Amendment rights being taken away because of unpopular beliefs.
At the time, many people were holding prayer sessions, meetings, and marches to abolish segregation in the South. Also, a few years later, one of the most influential speakers in American history would emerge with the same objective: Martin Luther King Jr.
I have a dream.
In this particular case, a group of 187 African American high school and college students marched from their church to the South Carolina State House grounds, which happens to be a public property.
Already forewarned of the protest, some 30 or more police officers were on the scene when the students arrived. They were told they had the right to be there as long as they were peaceful.
After they entered the state grounds, the students peacefully marched with signs stating their grievances to the people and government of South Carolina, their constitutional rights as citizens.
As onlookers gathered, police became nervous. The officers then told the students to disperse within 15 minutes or else they would be arrested.
Instead, the petitioners sang patriotic and religious songs and refused to leave.
Soon after, the students were arrested, taken to jail, and charged with the crime of breach of the peace. State trial courts convicted them, so the petitioners appealed their case to the Supreme Court.
The question before the court was posed as, how had South Carolina's common law crime of breach of the peace, as applied to a peaceful march to protest racial discrimination, infringed on the First Amendment guarantee of free speech?
The chief lawyer for the appellant was Jack Greenberg, and the chief lawyer for the appellee was Lionel M. McLeod. Justices for the court at this time include Hugo Lafayette Black, William J. Brennan, Jr., William O. Douglas, Arthur Goldberg, John Marshall Harlan II, Potter Stewart, Early Warren, Byron R. White, and Tim C. Clark.
In Washington, D.C., on February 25, 1963, the court decided in favor of the appellant with only one judge dissenting.
The Supreme Court decided that in order for an arrest to be made, there must be a clear and present danger for the protest to be stopped. The convictions were refuted as unconstitutional.
Bang.